following program on Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the laws surrounding ragging and other forms of violence in educational and other settings. Are the frameworks currently in place doing enough for the people of this country, or are we well overdue for reforms? A very good evening, and thank you for taking the time to join us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Tonight's topic is something I'm sure that everyone watching tonight would have had some sort of experience with. Maybe it's not directly experienced, maybe you were part of the whole process, or maybe you have heard of it from people that you interact with on their daily lives. And that's on ragging. I'm sure if you've been to any educational institution or university in Sri Lanka or abroad, you would have heard of this term. Maybe thankfully not personally experienced it, but a lot of us have survived and lived to tell the tale. So to speak about the effects of ragging and also the legal repercussions of ragging, and also what we can see in the law as to the frameworks that are meant to protect us against ragging, we have someone that is very well specialized in this area, and that is Gangulali de Silva, a Dayarathna attorney at law. Thank you very much, ma'am, for taking the time to come to speak to us in our studio today on this very important topic. A little bit of an introduction on Mr. Silva Dayarathna. She's someone with masters in law, specializing in law and social justice from the University College of London. And also to note, she also is a co-founder of this initiative called Break the Chain, where they have advocated in trilingual against ragging in universities. So safe to say we're in good hands when it comes to this specific topic. We can get right into the details. Before we do that, here's a little bit of a breakdown on how we're hoping to approach it. First, we'll be talking about the basics, of course, where the law lies when it comes to ragging, and then we'll be talking about the current context, what we see in present. Finally, we'll be talking about the future when it comes to the protection against ragging, and also what we can see as reforms moving forward. All right, well, without any further ado, let's get right into this discussion. We have a lot to break down. Once again, thank you very much, ma'am. We have to get into the legal specifics, but before we do, I think it's very important when it comes to, of course, public opinion and also what the public understands when it comes to ragging. There's a very vast area, right? And how specific the definition is, always it tends to get lost in context as well. It's a lot of gray areas sometimes, what people consider ragging and what they don't. So could you tell us a little bit, give us a little bit of an introduction into what ragging is in the public context, and also, most importantly, what the consequences of ragging can be?
Thank you, Anuradhi, for that very pertinent question. The term ragging itself, I'm sure a lot of us know already. Of course, there's like a formal definition of it under the Ragging Act that was brought in 1998, which is to say that any form of act that would be caused to a person or is likely to be caused to a person that will result in some form of physical, mental consequence or a fear in a student or even a member of the staff of the university administration is basically an act of ragging. But of course, going to the history of this concept, this is basically an initial process. We say it's a ritual sort of thing that you get to witness when you come into the university at the initial stage. Prior to this being called ragging, this was actually referred to as mal samaya, because it was supposed to be a very positive, vibrant period of your life where you enter into the university and then you get to know the rest of them. But with the tradition changing and it becoming more violent, then the term Navakavadya came in. If you look at platforms like Wikipedia or definitions.net for a basic introduction of what ragging means, it actually refers to Sri Lanka as a country where ragging is there to a greater extent. That is how bad this problem is. Now, to get into the consequences of ragging, actually it's not just one-fold. There could be physical damages, there could be psychological damages, there could also be long-term damages which we don't see as of yet until a student leaves the university. Physically, of course, there could be injuries, there could be death, We have very unfortunately seen a couple of instances where this has happened. Very recently in 2019 at the Sri Jayawardhanapura University, a student was admitted to the intensive care unit due to an alleged incident of ragging. Then back in 2003, a university student of the University of Moratuwa, I believe, was also murdered as a result of ragging. So the physical consequences are also of a large caliber. It could be like a very simple injury to a long-term paralyzing injury and then resulting in death. The best example is Rupa Ratnasili's example from the 1990s, I believe, where she was initially injured, then paralyzed, and then she took her own life ultimately, all because of ragging. Apart from that, in terms of the mental consequences, obviously there's things like depression and stress that you have to go through, but it could also result in things like sleep deprivation and other long-term illnesses that will affect your ability to study, do your daily work. As a result of all of this, ultimately you can be a victim of long-term mental disorders, long-term injuries, and also even lead into things like unemployment or generally not being able to live your daily life. So ragging as it is might sound like just one thing that takes place in your life, but it can have numerous consequences in the long run.
Exactly. We tend to see that in the public spheres, ragging isn't really given as much of an important position because they think, oh, it's an initiation. After the initial discomfort, it's more like how to get familiar with your batch or with your academia even, or maybe your faculty to become closer with them. I think we have to get into the legal aspects of it as well, because now we just spoke about the public opinion and what we see as ragging and how drastic the consequences are when it comes to ragging. Great preface for the discussion, but now we get into where the law lies when it comes to ragging. If you could provide us the information when it comes to the legal provisions that are in place specifically when it comes to ragging, the legal definition of ragging in Sri Lanka, and also added on to that how exactly it differs from other forms of harassment like bullying, for example.
Anuradhi, actually, ragging was identified to be such a grave situation that they had to bring a new law into place in 1998 in the form of a separate act to curb the act of ragging. So in this particular act, there's obviously a definition for ragging like we earlier spoke about, but there's a number of punishments that have been laid out for different forms of offences. To begin with, any act of ragging can, if proven, can result in a imprisonment term of up to 2 years, along with a fine to the victim. But if it's an act of ragging which involves grievous hurt or sexual harassment, this could go up to about 10 years. Then there's also things like criminal intimidation, which again bears a 5-year sentence. Also wrongful restraint or confinement, which could go up to about 7 years. All of these offences are there along with a fine. So at the court's discretion, they can order the fine along with the prison sentence as well. What we need to see is this Ragging Act of 1998 is actually really well done. It has more or less identified most of the forms of ragging that is there. Obviously not the mental factor has been touched in that. But most of the forms that is there, because things like wrongful restraint or wrongful confinement is something we often don't think would be in the form of ragging, but often happens in hostel context. I think a few years ago an incident was reported from the University of Peradeniya where senior students have actually rented out several places to commit acts of ragging. So these type of offences can definitely fall under things like wrongful confinement or restraint. Having said that, I also need to highlight that the Ragging Act has brought punishments, sentences bigger than what the normal law offers to us. So if you look at the penal code and compare the sentence to the same offence that is there in the Ragging Act, having tied it with the ragging factor, of course the sentence is more. So all those things have been included. But general offences like you said, bullying or harassment or criminal intimidation are again covered under the normal law, which is by the Penal Code of Sri Lanka.
So I think what you just obviously we have to talk about the most important act at hand, which is the prohibition of ragging and other forms of violence in education institutions, which was brought in 1998. The key legal provisions relating to that as well. I'd like to dive a little bit deeper into that act specifically because of just how pivotal it is when it comes to the protection of individuals that may face ragging. As you mentioned, it's a well done act, but we have to get into the nuances and the nitty-gritties when it comes to its application in the current context also. Could you tell us a little bit more about how you mentioned the penalties are more severe when tying in with the ragging factor? Can you walk us through the provisions that are in this act and also the penalties that have been listed out for ragging?
So Anuradhi, for example, if we look at the grievous hurt, voluntary causing grievous hurt offence under the Penal Code of Sri Lanka, the general sentence is one that can go up to 7 years along with a fine. But having tied it with the ragging factor, under the Ragging Act of 1998, it has been increased up to 10 years along with the fine. Similarly, when it comes to causing hurt, that is under the Penal Code, it's again up to 1 year. And things like criminal force, destruction of property, the sentence is actually for about 3 months along with the fine. In the Penal Code, of course, these issues have been identified or recognized in a general level, but there are plenty of other acts like the Ragging Act where separate issues have been identified, and based on the particular consequence, the nature of the particular act, the gravity it has, the impact it will cause on the society, then they have given aggravated sentences. So like I mentioned earlier, generally the minimum sentence for a simple act of ragging starts at 2 years. That's a maximum you can go up to. So even if it's going to be some form of mental harassment, then of course that can fall under an act of ragging, which can give you a sentence of 2 years. But having said that, Anuradhi, I also need to mention, with the COVID-19 pandemic, of course, there were ragging acts that were conducted online, on digital platforms. Could be via Facebook, WhatsApp, where people give like numerous calls to female students or ask for different details or photographs or try to harass them verbally over the phone in the midnight, several incidents like that. Obviously, this is not covered under the 1998 Act because during that time we didn't have this problem. But there are other laws in Sri Lanka now that covers online offences. For an example, the Cyber Protection Act that was brought in 2024 has numerous offences that are there that would cover this. Specifically, I think Section 20 covers an instance where someone would transfer your personal details to someone else without your own consent, and that has become an offence. So these acts and sections can be used for the purpose of punishing perpetrators of ragging. That is there. However, it's not expressly included in the Act. But that doesn't restrict us from using a different law that is already in place for the purpose of curbing ragging.
Exactly. What I believe I'm understanding is just because it is a form of ragging doesn't mean that we have to strictly rely on the act related to ragging. So. It's still an offense, and we can still, anybody that's seriously being affected by something related to, even as you mentioned, cyber related offences, we have mechanisms for justice to be sought out. Moving on now, you mentioned the Penal Code previously as well. When it comes to ragging related offences, how big of a difference do we see when it comes to the offences listed in the Penal Code and the offences listed in the current Act? Do we see a lot of protection in comparison with the Penal Code when it comes to the Act related to ragging, or are we seeing almost a similar level? As you mentioned now, 2 years of a sentence is almost the minimum for ragging related offences if convicted under it. Is the Penal Code playing a very major factor when it comes to scrutinizing and also, seeking justice against ragging?
How this works, Anuradhi, is that the Penal Code is generally the fallback legislation that we have. So say that something is not covered by the Ragging Act essentially, we can resort to the Penal Code, or if there's a better law than that, for example, like we spoke about the cyber-related offences, we can fall back to the cyber-related offences acts that are in place. Obviously, the punishments are more, but the burden of proof in showing that the offense has been committed is equally there. So as soon as a ragging related incident has been reported, the ideal course of action is to take action under the Ragging Act, because the University Grants Commission in their circulars almost all of the time refer to the Ragging Act, not the Penal Code, because that is a specific regulation that is there in place for this specific purpose. But if at any point if the law enforcing authorities cannot see a sufficient amount of the ragging factor being involved in a particular incident, then they can of course take steps under the normal law that is available there. This is not just limited to the Penal Code. Of course, there are other acts like the Obscene Publication Act, or let's say some other act in relation to where cyber offences are being addressed under. So all of that are there in place for us to make use of. But if we are going step by step, the first step is to resort to the Ragging Act of 1998. If it doesn't fall under that, if it doesn't satisfy that elements in that, then you can move back into the other legislation that we have in place.
Exactly. I want to ask you a question of curiosity when it comes to the Ragging Act. Where, in your opinion, do you see is the most significant area of the Ragging Act? Because now we understand that every piece of legislature has a heart and a key area that you have tend to refer to more often than not. In your opinion, what's the most fail-safe and the most airtight area of the Ragging Act that you have seen if you have gone through it?
I would have to say it has to be the second section, because it in detail lays out the types of ragging that could take place and the offences that are in relation to that. But then again, having said that, the necessary interpretation for ragging comes from the interpretation section that's at the very end of the Act. And I genuinely think, this is my personal view, I genuinely think the definition or the interpretation of ragging could be expanded much more, because this Act has not been amended after its enforcement. Yes. With changing times, with the changing nature of ragging, I believe that interpretation can be expanded, and if that is expanded, it will obviously have an impact on the second section where the types of offences have been laid out, and that will give a broader coverage to the acts that are going on now.
Exactly. I think we have to get into the reforms aspect as well. In the final segment, we'll get into that. But before we go in for a break, I'd like to ask you, I want to touch on this area also a little bit in the final segment for reflection purposes. But when it comes to other countries and Sri Lanka, how does Sri Lanka's legal framework compare in relation to other countries that have experienced ragging and also have ragging related regulations? Are we in a good position, or are we failing to catch up?
I think we have the law and we have the administrative mechanism in place. It's just that a matter of practicality, very similar to several other cases that we come across.
Exactly.
Because Anuradha, you see, this is not just a problem that is common to Sri Lanka. Ragging is there. Ragging is a common term used for acts of this nature in the South Asian region, like India, Pakistan, Bangladesh. But this is very frequently referred to as bullying in several other countries. And in the US, this is particularly called hazing, which is basically you putting another person through something, a very disrespectful activity of nature, when that person joins a group. This mostly happens in sorority houses in those countries, but also if you join different clubs and societies in the campus, that could also happen. In these countries, something that I see is the mechanism looks much more stronger or strict than what we have here. In the US, of course, different states need to have their own laws. So by 2019, over 40 states had their own anti-hazing law. But astonishingly, last year, they brought in a federal legislation for hazing that is called Stop Campus Hazing in 2024, which is basically an act. It's not just for the purpose of stopping hazing, but putting on an accountability mechanism on the campus. So at the end of each year, when the annual security report of the campus is being released, the campus has to provide details of all the hazing acts that have been reported. Obviously not without the names of the victims and the perpetrators, but just to have a general number or rough number for research purposes. For us to make laws, we need to know numbers. We need to have that research and data in place, which is something that we lack. And I think this is very progressive in that terms, because this puts on the responsibility on the campus to stop hazing, and they will have to monitor and take those numbers in and actually publish those numbers at the end of the year. In India, which is our neighboring country where ragging is there severely again the situation is similar to the US, where you need to have separate laws for separate states, and they also, most of the states do have laws, but the University Grants Commission of India in 2009 actually brought a set of guidelines which set forth a couple of new administrative mechanisms that they need to follow. One of the major things that I saw in this is that every university needs to have an anti-ragging committee. This is a committee which will monitor ragging related acts. The interesting part is this is not something that is just made out of university administration. This is of course the head of the university and all of that, but this will also include parents, students from different batches and different genders, representatives of local media. So it's just a very holistic committee in terms of handling ragging, and it's not just a responsibility of the university any longer. Apart from that, they have also a provision, a guideline to have an anti-ragging squad in each university, which I think is something that we're going to of course enforce, which is a team that would at random occasions visit student hostels, visit student gatherings, and assess whether acts of ragging is taking place. So in that way, I think many countries like this is a step ahead of us, because we are still relying on the old laws that we have, and I think a couple of circulars the UGC has brought forth, but there's actually no enforcing mechanisms. If we don't have people on the ground running to find where ragging is happening, it's going to be very difficult for us to eradicate it. And I think the universities on one end have to be held accountable in some way.
Exactly. I mean, it's the location and where exactly the ragging would have initiated in the first place. So of course it only makes sense that we have the universities take some form of accountability for the ragging that has been caused. I want to get into the enforcement aspect as well in the latter segments, but before we get into any of those specifics, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back after this. Welcome back to Law, Land and Liberty. We're in conversation with Gangulali Silva, Dayarathna attorney at law. We were talking about ragging and also the legal framework for the Ragging Act. And also we spoke a little bit before we went into the break about how internationally we see ragging being handled or tackled. And you mentioned a very important point there relating to the effectiveness of enforcement of the existing legislature. I believe that's a problem we have, you know, an umbrella problem that we've had across our legal system that we've tried to tackle through this series. But I think specifically when it comes to what we're talking about, enforcement is vital and essential. So if you could give us a little bit of an insight into how effective you believe you have seen law enforcement be when it comes to handling cases of ragging, and specific incidents when it comes to within universities and other educational institutions.
A couple of problems there, Anuradhi. One of the main issues that we have and we face is that victims actually don't approach law enforcing authorities or the university administration with regard to this. Or even if they do approach, in a couple of days they might withdraw, or they will refuse to give information, pertinent information that is in their hand due to factors like fear. So when it comes to effective implementation of these regulations, it becomes a bit difficult because it becomes one-sided at one point, because the victim, the campus, is not supporting the law enforcing authorities. While the laws are there in place, I think it's absolutely essential that starts with from the onset. But having said that, I also think there are several problems when we come to effectively administrating this, because one thing is a lot of people who are actually involved in making these regulations or guidelines, or actually speaking about this issue to begin with, might not have a grounded approach into the problem. So you need to might have gone through it or might have witnessed it at some point for you to actually be able to speak about it. Otherwise, I don't think you understand the gravity of what is going on. So while the University Grants Commission is doing a lot in terms of putting out regulations for the universities, it becomes a little impractical when you sometimes try to enforce those regulations in the practical sense. Having said that, I think law enforcing authorities to a certain extent is doing their job. But then again, there are often instances where law enforcing authorities will try to rather ignore or lessen the weight of a particular complaint solely because I think they are fed up with what is going on. It's a vicious cycle of someone coming before you and then withdrawing the case at a later point, which of course they can't be blamed about. Very interestingly, in 2024 October, there was a set of guidelines that was actually brought before the Supreme Court. That is how guidelines can be enforced in an occasion where the UGC or a university fails to act on the regulations that are already in place. But last I hear, this is still in the draft form. But an important thing has been introduced, that is to have a victim support committee in each university, which I think we are severely lacking, because to begin with, we rarely have counseling services that are active within the university community. But a victim support committee, I think, would give really that push or that nudge where victims now have to take their complaints and go through with that process for the effective implementation of it. So I think book-wise, theoretically, we have things in place, but when it comes to the practical implementation of it, there's still a little bit more to be done.
Exactly. We have to talk about the lapses in practical implementation in more detail when it comes to the future of ragging-related offences that occur in Sri Lanka and what we can expect to see as a trend moving forward as well. But before we get into that, I wanted to ask you specifically, you mentioned, of course, support groups, ragging, anti-ragging squads, basically small units that can be used for the better implementation and enforcement of anti-ragging policies. Do we have such specialized task forces that are currently active in any universities? Has the Act mandated any sort of accountability council, or is there any sort of group that has been mentioned specifically by any legislature that we can see mandated but not in active performance? Or do we not see anything of that sort across the board in any universities in Sri Lanka?
I think specialized is a subjective term when it comes to this, because from the onset, one of the preliminary issues that we have is actually officials don't have a formal training on what ragging is and how to handle a particular situation of that nature. They just play it by the books. But of course, on university premises, there are certain officials called university marshals who are constantly supposed to monitor the disciplinary nature of the students, and they can take action with regard to ragging. But unfortunately, there has been incidents where these marshals have in fact supported the acts of ragging or turned a blind eye towards it. While that is in place, there's also the university administration, which is bound by the UGC circulars to take action with regard to this, and there are certain regulations which impose a mandatory responsibility on the university administration to report acts of ragging to the police and the UGC. Apart from that, I think there are also certain communities within universities, student groups could have a political backing or not, but they essentially identify them as anti-ragging student groups. So when you go join them, you have like a protection circle around you, and they identify you as a person who is not ragging other people, therefore you won't be ragged. So that type of mechanism is there, but like we spoke about India before or the US before, there are no anti-ragging squads in our country. The victim support committee that we have discussed about, it's still not there in place. So in terms of forming different groups or societies to help out the victims of ragging, there's still a bit more to be done.
So going back, a question of curiosity again, when it comes to the Act, we see that for the prosecution and persecution, or the accountability aspect of the physical acts of physical or of course otherwise acts of ragging, we see that there are repercussions that are listed. Are you saying there's no deterrent aspect of that act in its nature by existing? Because we see that the legislature exists, but we don't see any practical application.
One thing we need to realize when we discuss about this is obviously loss delay is a problem, Anuradhi. That's a common problem that we acknowledge. With that comes a lot of other issues where with the expanding time period, there's a lot more impact on the victim. So there may be cases where there's evidence that can actually be lodged against a particular perpetrator, but during the course of the investigation, the victim either doesn't want to present them, or they become insufficient for the ragging act, or they get lost in the chain, something like that. So the law is there, but when it comes to putting the law into play, it's a bit tricky than we think. It's not as easy as saying, okay, look here, this is the person who did this, these are the particular evidences that is against this person, therefore please punish him before the law. It is not as easy as that. It involves a lot of other parties, and what happens is generally when a complaint is lodged under the act, there's a lot of third parties which come and flock around and try to influence this particular thing. For one, it could be people who are anti-ragging, who want to carry this forward. But also it could be majorly student unions and other communities within the campus who certainly pose a form of threat upon this particular victim not to carry this forward. So what happens is they will obviously take a step back. And I think the recent most example would be the 2019 incident at the University of Sri Jayawardenepura, the management faculty, where a tire was toppled on a student and he was in the intensive care unit for a long period of time. If I'm not mistaken, there were 4 to 5 perpetrators who were arrested and remanded, but several of them were granted bail within a very short period of time. I understand that there may be reasons for that, but then again, if we don't understand the gravity of the act of ragging, someone would justify granting bail to another university student. But if we are to set forth that message or a precedent in terms of punishments for ragging, I think it's essential that some perpetrators actually get punished before law.
Exactly. We have to see the law an example in order for it to be a deterrent in the first place, of course. And basically we see not much conversation around the Ragging Act as well. So we really need to consider just how effective a piece of legislature can be without its influence and without its knowledge of existence sometimes even. I'd like to ask you, we mentioned the University Grants Commission previously as well, but I'd like to get into it specifically with this question. How big of a role does the UGC, the University Grants Commission, play when it comes to the prevention of ragging or even addressing ragging when it comes to university setting?
Their role is massive. There's a lot that they can do, and they've been trying to do a lot also genuinely. To begin with, the UGC is involved in rule making for universities. That's why they release different circulars to the university administration pertaining to ragging. But other than that, the UGC also has a particular division where they handle complaints pertaining to ragging. So once the university reports an act of ragging, the UGC will obviously be involved in investigating into that particular incident, or if a victim directly complains to the UGC, then also they can get involved in the matter. In 2020, I believe, there was specifically a ragging relief committee that was formed under the leadership of former Justice Dr. Salim Massouf, where students were given the opportunity from starting on, I think, 2015, victims of ragging were able to submit their complaints by way of affidavit and evidence for this committee to take action, because there were plenty of students who had actually gone through ragging who did not know what to do, whether they wanted to go to university, whether they wanted to pursue their subject course in that particular university. And there were over 80 complaints that were received by this particular committee. They obviously went through like an interview process and weighed out the pros and cons of everything. And certain decisions were given to these students. Reliefs were given in terms of whether they can change their university altogether or change their department, whether compensation can be given and whatnot. But that just happened at that point. Right now, there's no ragging relief committee. That was just that. It was a good committee consisting of like experts in the field. But then again, if it continued, if it was something that is always there for people to access, it would have been much more effective. So I think the UGC can bring back mechanisms like that to of course see that victims of ragging are comfortable in their setting. The UGC is definitely involved in matters with relating to curbing ragging, but I think, like I said earlier, the practical essence of it needs to come into play a bit more.
Exactly, and as you mentioned, of course, there were certain administrative protections when it comes to, in a brief period of time we saw that it was effective, and there were results when it comes to delivering some sort of relief to the affected parties. But right now, in the current context, in universities across the country, how exactly are victims right now encouraged, the victims of ragging encouraged to actually come forward with their claims? Is it only through the act, or since the UGC has not continued the acts that they have been trying to carry out over the past few years, where do ragging related victims even turn to at first?
One thing is that I would say that a victim of ragging is generally left by themselves to a large extent, unless of course there's a separate movement within the university which caters to anti-ragging, then they will obviously support them. But I know for a fact, in my experience, I was left alone in the particular incident, right? So I had to do what I wanted to do. If I didn't want to push for administrative action, it might not have happened, action might not have been taken. So victims in general are in a very blank headspace when it comes to ragging related incidents, because of one thing, they're actually going through the act of ragging. They might have some physical damage or mental damage caused. Secondly, they might not know whom to reach out to, because in some instances there's also this common opinion where certain administrations does support ragging. So the victim is not sure whether complaining to the administration essentially will make that difference that he or she is looking for. So with all of those doubts, a victim generally thinks not just once or twice, but several times whether they need to pursue the mechanism before law. I think universities are doing a fairly good job right now in advocating or creating awareness with regard to how ragging related complaints can be handled and managed. But the problem is no one really sees it being practically done. So you just don't know whether the mechanism is there and whether you can go through with it or not. That's something just you don't know about. So I think all over, universities have different things to help victims of ragging, but awareness about it is severely lacking, and victims are not encouraged sufficiently to go before this mechanism.
I want to get into, of course, victims already with the burden that they have placed on them when related to the act that they have faced through ragging. It's a task and a half to even, actually come clean about it and actually tell somebody, because it's almost an accepted tradition and part of the culture almost of most universities. And as you mentioned, the administration could be working against not promoting ragging as well. So we've been talking about the victims as we should for the better half of this program, but I want to get into the perpetrators specifically. When it comes to, of course, someone that has been found guilty of ragging, how exactly, what measures are in place? Does the act by any chance detail how those found guilty are to be treated after? Is there rehabilitation? Is there reintegration? Because again, the perpetrators are also students that were pursuing an education in a university. They're not, state criminals, but they have committed a very serious act. Is there rehabilitation programs in place? Is there reintegration in place? Is there some sort of repercussion when you come back to university, maybe after your sentencing?
No. It's just when I was thinking about this, whether there's a rehabilitation program for perpetrators of ragging, I actually drew a blank because I had no idea whether there's a mechanism as such, and I did a bit of reading on that, and my answer is still no. While there's a method for the victims to go before the law and be brought into the university again, there's no real method for perpetrators of ragging to be rehabilitated and mingled with the system again, which is unfortunate, because I think that is where we need to fix the problem first. Because you see, Anuradhi, circulars like the Circular 946 of the UGC expressly lays out the punishments that you can give to a perpetrator. It could be expulsion completely, or it could be a suspended sentence where you're not allowed to come to the university for about 2 years, or it could even be something like withholding your exam results or your degree certificate, things like that. The punishments are there, but not really the rehabilitation mechanism, not a mechanism to send them into counseling, not a mechanism for them to engage in social activities and develop their soft skills or learn how to deal with other people. Nothing of that nature, which is really unfortunate, because we are trying to fix a problem without actually fixing the people who cause this problem. I think that is something we really need to give thought to, and as for the question you asked me, the answer is no.
Exactly, and that's very alarming as well, because we have to fix the root cause, otherwise the roots will continue to spread, and we have to see some sort of mechanism in place so that we can curb it at the root and not have it, you know, we're not treating the symptoms, we need to find a cure. Before we get into any of the specifics related to the future of ragging and its related incidents in Sri Lanka and how we can seek protections in the legal field, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back after this. Welcome back to Law, Land and Liberty. We're in our final segment in conversation with Gangulali de Silva, Dayarathna attorney at law. And thank you very much for the previous 2 segments. I believe we covered a very heavy topic and we broke a lot of ground, and we got a lot of information. I believe the viewers would have a much better understanding related to ragging. It's not just, you know, a word that we throw around. It's an actual thing that affects people on the day-to-day and has lasting effects that we still haven't been able to study yet. And the act, we see hopes to curb some, but we see serious lapses, as we just touched on right before the break. I'd like to ask you, when it comes to the universities and their disciplinary actions, not the act, separate to the act, what implementations have you seen, and are they effective at the moment?
Under the UGC circular specifically, Anuradhi, the university administration has certain duties to comply with. To begin with, they necessarily need to have an investigation or an inquiry into an act of ragging if it's been reported. These are specifically highlighted in circulars such as 919, 946, and I think in 2019 there was a separate circular that was brought just for sexual and gender-based violence related activities. So in all of these, of course, it says that there has to be an investigation. And specifically in 919, it says that if an act of ragging is being reported to the administration, they have to make a police complaint, they have to report it to the UGC, and they have to also collect evidence pertaining to this. So in that level, the UGC does have certain responsibilities, and when it comes to sexual gender-based violence, the administration also has to give the necessary support to the victim of that activity, not just in terms of writing down a complaint, but also to see whether they need treatment physically or mentally because of the ragging incident. I think universities alone by themselves, they can have in place their own anti-ragging policy. I think the University of Peradeniya has a very comprehensive ragging policy in that term, where they have actually covered all of these areas, not just the investigation complaint mechanism, but also the aftermath of it, as to how a victim can be treated there afterwards and whatnot. The UGC essentially has imposed a great amount of responsibility on the universities, and it is up to the university to actually see that it is being done.
So that's the important part. There's been circulars, but we need to see enforcement. I feel like that has been a running theme throughout this discussion and throughout the series in itself. I'd like to ask you now specifically, as we are closely running out of time as well, we spoke about the rehabilitation aspect and the lacuna in the law when it comes to that as well. But I'd like to ask you about the awareness programs, or specifically the education that is required for students and faculty to prevent ragging from occurring in the first place. do you see any sort of mandatory programs that have been implemented in universities, and also specifically when it comes to the student side, when it comes to the student unions as well, do you see such authorities or regulatory bodies actually trying to form mandatory awareness programs or even raise better awareness for this issue?
Not mandatory programs across the board. Certain universities will have their own policies, but under the UGC Circular 919, all university students have to sign a declaration form before entering university, and we were actually served with a copy of the Ragging Act along with the declaration. It's basically saying, read this, sign this. If you commit an act of ragging, there will be repercussions for it. That is the only mandatory requirement that I have seen so far, but generally universities in their orientations or their initial programs to enroll students, they do have certain segments in relation to ragging and how to deal with it. So that level of awareness is there, but every other effort I think is very secluded and done by different clubs or societies in a university, or targeting a special group, or if an incident is reported, then with regard to that, it's not an across the board approach where everyone is addressed in a very similar way. So there's that bit lagging. Obviously, I think the UGC has different things in place. It specifically has an online complaining mechanism, a portal where you can report your complaints and all of that, which I think, like leaflets and brochures and posters and all of that, is there in university premises. As to whether students use it is questionable.
That's the problem. We have to see more proactiveness when it comes to reaching out against ragging as well. When even affected parties, they have to stand their ground and actually make sure that a complaint follows through. Unfortunately, it's not as easy as the complaint is taken and the process is executed flawlessly. We have a long ways to go when it comes to that. We're almost running out of time, but I'd like to ask you specifically when it comes to the legal aspect, legal or administrative aspect. We need to talk about reforms. Do you see in the legal sphere any sort of lobbying brought up against for the reforms aspect of this piece of legislature? We have space for reform, of course, but what is the most important aspect you think that we have to touch on first and foremost if we are going in for a reform of the law?
Anuradhi, I think there are plenty of groups speaking about this. There are anti-ragging groups that are trying to do something. In fact, we from Break the Chain also delivered a set of proposals to a former president requesting to take action on this, and we laid out a very detailed action plan as to how this can be approached. In terms of reform, I don't think reform is something that can just be done at a university level. It has to first begin with the school. It has to be a school-oriented program to begin with. So maybe for the A-level students, you can have some form of 2-hour awareness session, because these are the students who are going into university. If you can have an awareness session as to what ragging is, what you can do, and why you necessarily need to not rag, I think that's the starting point, because that's where we break that particular cycle, because these are the new kids that are coming into university. Secondly, in terms of university, I think we already discussed that the laws that are already in place, but it might be helpful to have a rule book which is accessible to anyone, or a simple, even like a leaflet or a pamphlet where all the information has been laid out for a victim of ragging. Apart from that, I think there can also be certain improvements in terms of how students are being integrated to the university system, because what happens basically is a student will come to the university, there will be an orientation program, and they are directly thrown into the lecture hall. Whichever activity that they want to do, they can pick. But obviously there are better things that can be done rather than ragging to mingle those first year students with the university community. This could be volunteering projects, religious celebrations, different competitions, literary festivals, anything of this nature which is given for all years of students to organize and conduct, so that they actually get to talk to each other and get to know each other. When that happens, ragging is not going to be required, and a major cause of ragging, which we call, is like the superior class mentality and the class jealousy and all of that, will obviously not be there, because you're talking to someone in a very friendly sense. I think it's also very important that in terms of reforms, that we bring in a counseling service for the universities, for each university, for victims and also perpetrators of ragging, to go through and talk to and get the necessary help they need. And something interesting that we have been suggesting is to have a Rate My Ragger website. which is basically a website where you can upload or give the information with regard to a ragging incident that has happened to you with the necessary proof or evidence. It will obviously go through a monitoring process to evaluate the accuracy of the details, but then those details will be published. So this will be given access to different companies or institutions. So when they're hiring a person, they have that choice to whether to look at the website. If the person is a perpetrator, they can decide whether they want to hire that person or not. This is something that has been actually proposed in a very novel sense, which requires IT help. But I think in terms of reforms, we need to also look as to where the perpetrators will be held accountable. They will obviously get university education and go outside, and I think they need to be held accountable outside of the university premises also.
Exactly, because ragging is not an act that stays within university walls. It follows the victim, it haunts it, you know, wherever you go, you will carry the effects of ragging with you. I think unfortunately we have come to time with our discussion here tonight. We have a lot more to get into when it comes to the nuances of ragging as well, and also how the international community learned to, you know, have better protection mechanisms. Even our neighbors have better protection mechanisms through the law, unlike us, which we really need to look into, specifically the lacunas in the law. But I believe we covered a lot of ground here. Thank you very much, ma'am, for taking the time to explain to our viewers about the effects of ragging and also the laws surrounding ragging as well, which I'm sure many would are yet to learn about. They probably have a better idea now. Thank you very much.
Thank you, Anuradhi.
All right, well, we leave you tonight with the words of writer Isaac Asimov. Violence is the last refuge of the incompetent. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/AnuDayana English. Thank you very much for watching. Have a great night.